Hello, and welcome to another installment of The Youth and the Law. I am Pierce, your facilitator for today, and we are going to be talking about product liability. So for right now, we're going to be talking about the Cronut Cases. If you don't know what the Cronut is, at the C&E they had just this one place where you could buy this burger called the Cronut, which is a regular burger, except the bun is actually a donut and croissant sort of hybrid. And there have been 34 cases of severe sicknesses that were brought to court. And as a result of that, they just got rid of the Cronut. So these are our panelists for today, Trayvon and Ryan. And so I want to ask you guys, what are your opinions on the C&E Cronut debate?
Well, my opinion on that. Well, you know, with something that's like, it's a donut and it's a burger and then it's another donut, okay? So I mean, you already know looking at that, okay, this is obviously not like the most healthiest thing. I mean, it's two donuts that you're having, probably, I'm guessing it's one at the top, one at the bottom, right, at once, right? So you obviously know it's not the most healthiest thing.
Personally, I'm not surprised that they're no longer selling Cronuts because you have so many people who are getting sick from this. It's not a product that can be sold.
Okay, and our second question, in a California case in the 1990s, a guy choked on a 1-inch chicken bone found in the chicken enchilada he was eating. The court found the restaurant non-liable because the chicken bone was a natural ingredient of the chicken meat. Is the same true for the bacteria found in these Cronuts, do you think?
It's really hard to say because you're not going to think about bacteria as being a natural ingredient in your food, maybe. So maybe not. You know, I wouldn't look at anything bacteria. I look at anything calories. I don't think bacteria.
Exactly.
That's just me.
Yeah. What about you?
Well, the bacteria comes with food, but like there are bones in chickens. Bones are part of food, but disease with food, that wouldn't be considered natural.
Okay. So if you were to go to a store and buy canned food and were to find, I guess, you know, an insect like a cockroach inside of the canned food, do you think that the company supplying the product should be liable, or do you think that's a natural consequence?
I don't think that's natural. I think the company supplying should actually be liable. Because how the heck does something like that, how does something like that just get into the can?
Exactly.
I mean, I don't think, there's no way that, cockroaches don't naturally grow in canned food, right?
So we're going to talk about another case now, a case that happened in the United States. So after consistently smoking American tobacco cigarettes for 35 years, a man gets lung cancer, which obviously that is pretty inevitable to happen, right? Man blames the cancer on the cigarette company's failure to disclose harm posed by cigarettes. Court agrees partially and disagrees partially. Court believed the harm of cigarettes was common knowledge. Thus, cigarette company was not required to warn consumers about smoking's ill effects. So obviously this is a long time ago because now all on the cigarette packages you see all the warnings and the side effects and everything. So on the other hand, the court believed that the addictive nature of cigarettes was not common knowledge. Thus, cigarette companies should have warned consumers about the dangers of being addicted to cigarettes. So do you think that the cigarette company should have been liable, or do you think no, that the consumer should have taken that?
For the addictiveness, perhaps.
Maybe the addiction part.
For the addiction
part. For it being bad for you, I don't think so.
Yeah.
I think, you know, a lot of people knew that, and that should have been common knowledge. I mean, and just smoking a cigarette.
Okay, something else that we should cover is Escola versus CocaCola case. A Coke bottle explodes in waitress's hand. Court says a duty of care was owned by manufacturer. Coke conducted extensive tests on their bottles, but they also recycled some old bottles that were assumed to be safe. So do you think it was responsible of Coca-Cola to reuse the bottles, or do you think they should not have to?
No, I don't think it was too responsible of them, because I mean, once the bottle gets tested once, right?
Yeah. And
if it gets brought back and they just say, okay, put it back because this has already been tested. The thing is though, when that bottle is out there, it's gone through, you know, and it's gone through different, I don't know, impacts or something. I think that is their fault for not retesting their used bottles, and it was. They lost that case.
Yeah.
Well, it's kind of you have a bottle and it came back in a different state. If they could prove that the bottles that they got back were safe, then they wouldn't be liable. It would be a different factor. But as it is, if they didn't put the extra effort and if they can't prove to court that these bottles, especially the bottle that did explode, because that's not something that should happen, it's dangerous. If they can't prove that this is natural or if they can't prove that this is safe, then it's definitely liable.
Yeah. Okay. And something else that we should focus on is Buick motor incident back in about the 1930s, 40s maybe. A car explodes. Bad auto parts, court says manufacturer is liable, even though there was never an original contract between plaintiff and manufacturer, only between retail and manufacturer. So what do you think it is exactly that the manufacturer probably did wrong and should have paid attention to?
A car explodes. It's clear that something has gone wrong. Whether they should have done more testing, that's indefinite.
Do you think maybe the company shouldn't be 100% fully liable because this wasn't something that was happening repeatedly and they never really took initiative to fix the problem? So
Yeah, I don't know. Maybe either the company or because they're all coming from the same.
Yeah.
The damage is still dealt. You already have to pay for that. But the fact that this happened, I don't think they need to be punished further for extra fines, but just pay for the original damage of the car exploding.
Yeah, and then sort of move on with further testing and try to solve all the problems that you've caused. So that's it for today's installment of The Youth and the Law. My name is Pierce, your facilitator, with our panelists, Trayvon and Ryan. Thanks for watching, and we'll be back soon.